one of the first things that we talked about for acceptance is it must be an unconditional consent to all the terms of the offer, right? Okay, so that is one of the first things we talked about. Then you remember mode of communication. So when we communicate our acceptance, we are supposed to use a reasonable mode of communication. Yeah. But if the offeror has already indicated, he said, please use this mode and nothing else, then we are supposed to follow that mode which has been prescribed. Okay, so that is what we studied. And then remember acceptance subject to a contract. So if the agreement has got this clause which says agreement is subject to contract, so what is the implication? Not binding yet. The agreement is not binding yet. So in that kind of a situation, the buyer can also actually what? Change his mind. A buyer can change his mind and not proceed with the contract. And yet you cannot sue this guy because in the first place, the first contract was not even binding. And then the seller can also back out. So if the seller is not interested in selling, he can also back out. All right. So both the buyer and the seller, they are not obligated yet. Are you okay with that? Huh? So that is the implication when we put the word subject to a contract. What was the other word also gives the same implication? Yes, correct. Binding in honor. So sometimes they write the word binding in honor. The implication is the same. The contract is not binding as such. Are you okay? So in the case of subject to contract, what must the parties do? Because they won't put the clause subject to contract, yes or not? So it is not binding, yes or not? So what must the parties subsequently do? Of course, enter into another one, agreement. They must prepare another agreement. The terms and conditions can be exactly the same. Even if you want to change also can. All right. But more or less it can be the same terms and conditions, but the parties will have to sign again. So once they sign again, and then that becomes the what? Enforceable contract. That becomes the binding contract. Are you okay with that? Huh? So that is the implication when we put the word subject to what? Contract. Are you okay, guys? Can now? So that is what we talked about yesterday, subject to contract. And you remember this one? Silence can never amount to what? Acceptance. Even when this is stipulated in the offer letter. So therefore, you see, silence doesn't about by this guy just keeping quiet doesn't mean what? Accept. All right. There must be some positive act of what? Acceptance. That means basically, what must the offeree do if he wants to accept? He must communicate. He must communicate to the offerer and tell the offerer he's interested. Okay. So there must be communication of the acceptance. Now, the only exception is what? Where communication is not necessary. Yeah, correct. Unilateral contracts. Remember Khalil against Carbolic Smoke Ball? In the case of unilateral contracts, there is no necessity to communicate because acceptance will take place by what? Conduct. Remember, just perform the act. Right? So that is the only exception. Otherwise, communication of acceptance is necessary. All right. And again, as usual, guys, as much as we talk about communication, which is essential, we also studied yesterday so many times that it must be effectively communicated and all that. When you make an offer, you must communicate. And effective communication takes place when the other party has knowledge. When you revoke the offer, also say. When you want to revoke the offer, also you must communicate. And the other party must have actual knowledge. Correct or not, guys? So it's always communication. Effective communication means the other party must have actual knowledge. So now when I say acceptance also must be communicated. So when you say acceptance must be communicated, again, when does effective communication take place? The other party must have what? Knowledge. The other party must have knowledge, yes or not? So look at this case of Angels against Miles Far East Corporation. You see in your notes when it talks about, see? Acceptance, therefore, must be communicated to the offeror by the offeree or by an authorized agent. And it says here, effective communication takes place when the offeror has actual knowledge of the word acceptance. And then you see that case is Entos against Miles Fires Corporation. So you know what happened in that case, Entos against Miles Fires Corporation. This company, Entos here, and then Miles Fires Corporation, the other company. This company was located in London, you know, and this one was in Amsterdam. And then this company made an offer to the other company in Amsterdam. So they made an offer. They used telex as their mode of communication. Now, nowadays we don't use telex. Right? But those days we have this mode of communication by telex. All right. So they sent by telex their offer to the other company, which is located in Amsterdam. Then this company accepted the offer, so they sent back their reply indicating acceptance also by telex. So this company communicated back and informed this company that they are okay, they accepted it, so they also replied by telex. So the question is, guys, in which country did this contract take place? See, offer is there, acceptance is there, yes or no? So in which country did this contract take place? Did the contract take place in Amsterdam or did the contract take place in London? London. So why do you say London? Because acceptance must be communicated, yes or no? And when does effective communication take place? When the telex reaches the other side. So the telex must reach what? London. When the telex reaches London, only then effectively the acceptance has been communicated, yes or no? So the telex must reach London. So guys, which country did the contract take place? London. So because it took place in London, so the English law will apply for this contract. Alright, so it depends in which country the contract took place. So the law of that country will apply. So what they're trying to say is, acceptance must be communicated also. And effective communication takes place when the other party has knowledge. So the telex is in this case must reach the other side. Then only effectively communicate. Are you okay? So that's the general rule when we talk about communication. Alright? But you know, you look at the paragraph down here, exception is there. Exception to the rule on communication. So first of all, make sure you know what is the general rule first. Because here we're talking about exception, right? So again, to recap again, guys, what is the general rule? Acceptance must be communicated. And effective communication takes place when the other party has actual word. Who's the other party? The offeror. The offeror must have actual word knowledge. You must know about this acceptance. So that is the general rule, which is basically reinforced in the case of Entos against Miles Fires Corporation. Are you okay? But you see the exception that appears there. The word exception says here what? Exception to the rule on communication. And you know, it says postal rule here. If the parties have contemplated the use of post as a means of communication, acceptance takes place when the letter correctly addressed and stamped is placed in the letterbox.